Well, 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 look who we have here. It's the old Deputy Blake Fisher and old County Attorney Jill Gillett. Yes. Both of them, I think, together.
Now for all y'all who ain't heard of me, Mr. M.O.E. I'm a Southside living legend, a third ward, bone hard, street veteran. It all started in 93. High school was a fool, I was only 18, with the dreams of becoming a ghetto superstar. Rolling a foreign car through the streets of Third Ward. It was hard, Bible storming with the...
That's fine. User turn signal 100 feet. After observing those two violations, I effectuated a traffic stop.
Okay. And where approximately did the car come to rest?
At the approximate 326 mile marker on US Highway 400 in Greenwood County.
At the approximate mile marker in Greenwood County on Highway 336, I'm not a robot and I am not reading this. I am just talking like this because I like to talk like this. Yes.
At the approximate 326 mile marker on US Highway 400 in Greenwood County.
And once she did stop, did you run the license plate and her driver's license?
I did. I ran the license plate of the vehicle and the owner of the vehicle, Miss Stowe, the address showed to be in Longton, Kansas.
Was she able to, as the dog was going to provide a free air sniff, did the defendant talk with you any about the situation?
After the free air sniff?
Yes.
She said that she wasn't going to consent to any search or seizure.
Okay. Did she admit to having drug history?
Not that I can recall. Well, I do believe that she did mention some in her past, yes.
Okay. And then during the probable cause search, did you note anything of value or evidentiary value?
So I located a tetrahydrocannabinol or THC vape pen in her purse. There were THC gummies that were found in her purse, and then I found THC gummies that were found in her purse, and then I found a bag of methamphetamine inside of her purse. Found in her purse, and then I found a bag of methamphetamine inside of her purse.
I'm sorry, Deputy. I didn't hear you very well. Can you read that again for me one more time where you found this one bag of methamphetamines?
Okay. And with the methamphetamine inside of her purse, did you find anything else besides the methamphetamine?
As in?
Were there additional baggies or other things?
Just what I can recall right now, just the THC gummies and the vape pen.
Okay. And with the methamphetamine, what was the weight of the methamphetamine that was found?
1.5 ounces or 44 grams.
Did Stowe, after you found the methamphetamine, admit that that was all she had?
Yes, she did.
Okay. And did you then send the methamphetamine to the KBI lab?
I did.
I don't believe it.
And when it went to the lab, Judge, I believe we have the results back that have been emailed to Missy.
Missy, do you have those available?
Yes, I do.
Thank you.
Found in her purse, and then I found a bag of methamphetamine inside of her purse.
Counsel, you've received a copy of those?
I believe so. I think Jill forwarded those to me, yes.
All right.
December 2nd, a month ago.
Yeah.
Okay, please proceed.
If Missy can share those, we'll be moving to admit the lab results as states 1.
Okay.
And here's why I don't fully believe her is because the way she presented it, when she brings it up, you can't see the bottom. It just cuts off right there, right? And also, too, I'm aware that most labs have a barcode or one of those square things that you scan with your phone now or whatever. They look like this. Also, too, it literally says, do not mail to this address. It says to, like, take it into the location or whatever. So when she said, did you send it to them? It just was kind of weird because, you know, you're supposed to take it to them, not send it to them. But, I mean, I guess you can certify mail it. I don't know. I mean, this just doesn't add up because, look here. It says it was submission number 1 received on 8/27/2025 sent certified mail. So it took them, 3 months before they even decided to start testing it? And then when they did test it, it only took a day and a half? You see right here, it says item number 1, 2 plastic bags, right? And then start date of examination, 11/18, and then completion date, 11/21. What the fuck?
States 1 is admitted without objection.
And Your Honor, you can see on that the net weight of the 2 bags was 25.49 grams when they were weighed by the KBI lab.
Hold on. What did this bitch just say?
Net weight of the 2 bags was 2
bags, she says. And then he said before that he's literally reading this off his report, that it was...
And then I found a bag of methamphetamine inside of her purse.
Oh, so it's half of that, which is like roughly 13, right? Okay. But homeboy said...
What was the weight of the methamphetamine that was found?
1.5 ounces or 44 grams.
Okay, but Gillett said that it was...
Net weight of the 2 bags was 25.49 grams when they were weighed by the KBI lab.
So KBI says that the net weight is 25, so 2 bags of 13, basically, and he's saying that it was 44. So I'm no mathematizer, but sounds to me like there 18 grams went missing on the way to the CGI or the KGB or the KSI or the whatever the fuck it's called. If she read that wrong, and the 26 really is half of it, so it would be 26 times 2 would be way over 44. So there would still be some missing, no matter which way you look at it.
And the gummies were 65.17 grams.
Okay. Noted.
Yes. The photo of what the methamphetamine looked like in the first bag.
Yes.
And is this the photo of what the methamphetamine looked like in the second bag?
Yes.
Your Honor, those are the photos taken when the mobile detect.
Mobile detect, you say? I wonder. Yeah.
Tests were taken with the presumptives for the methamphetamine. We would move to admit those photos as State's Exhibit 2 being. And is this the photo of what?
Yes.
And is this the photo of what the methamphetamine looked like in the second bag? Your Honor, those are the photos taken when the mobile detect tests were taken with the presumptives for the methamphetamine. We would.
Still, that's evidence of nothing. And on top of that, this is all evidence that she's introducing. They had the day of the arrest. Why did they have to wait 4 months for the lab thing to weigh it? You know what I mean? They're just going literally off the test that he did himself on the scene that day and the pictures that he took on the scene that day. None of this has to do with the Kansas Bureau of Investigations. All the evidence she's entering is just all stuff they've already had.
Move to admit those photos as State's Exhibit 2 being 2 pages.
Any objection, Mr. De Hoya?
And for the limited purposes of today, I do not have an objection.
I would object because those are just straight up crime scene photos. You know what I mean? They're just pictures of what they found, right? And somehow they're trying to tie that into it being part of the Kansas Bureau of Investigation's report when it's not. It's just pictures he took on the scene. He literally took those pictures with his cell phone of whatever he supposedly found. Mobile detect test, okay? It's not mobile as in, oh, it can go with you in your car and you can use it in the field. No. It's mobile as in it's an AI-powered generated app on your phone that you use to test drugs. Give me a fucking break. It's because it's not evidence of anything. In fact, it's evidence of nothing because they specifically explained to you this here whenever they here, I'm going to have AI tell you about the AI that you download on your phone to test drugs. Let's see what the AI thinks about its own work. So, mobile detect systems manufactured by Datachem is designed for a safer, more efficient alternative to traditional field drug tests like NIK or NARC2. The process generally involves 4 steps: swab, run the test, observe the color, analyze results using the free mobile detect app available on iOS and Android, which scans the pouch's QR code and color reaction to provide an automated objective result, removing the potential for human error or subjective intervention or interpretation in varying light conditions. Wow. And here, as the name implies, these presumptive tests, meaning they indicate the possible presence of a substance and do not provide definitive proof of a positive result, often needs to be confirmed by a certified laboratory to be used in the criminal case. False positives can occur, especially with similar stuff, blah, 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 right? But why then are they using the tests, this actual test, as evidence? It's stupid.
1.5 ounces or 44 grams.
Net weight of the 2 bags was 25.49 grams when they were weighed by the KBI lab. And Deputy, did you end up recovering the Tudor straw that was in the driver's side door panel as well?
I did.
Was there any further admissions of the defendant as to how she had obtained the methamphetamine?
She obtained it in Wichita.
And did she admit that to you?
Yes.
And Deputy One, did you notice any drug tax stamp on any of the drugs that you found in the vehicle?
I did not.
And did you purchase any drug tax stamp when you mailed it to the KBI, supposedly?
Let's talk a little bit about how you had to gain entry into the car. When Ms. Stowe was getting out of the vehicle, did she do anything to hinder you being able to get back into the vehicle?
She locked the door and did not provide us with the key to gain back entry into the vehicle.
And did you ask her if she had the key to be able to gain entry back into the vehicle?
Yes, and she was not giving us a clear answer. I did observe that the keys were laying inside the vehicle.
Okay. How did you end up having to get into the vehicle?
Sergeant Cordell had to break the window.
And did you then end up being able to search the car?
Yes.
Did you hear that? What was standing in his way from searching the car wasn't the Fourth Amendment and wasn't her refusal to be searched, but it was the window that was standing in the way from keeping them from searching the car. This is bad. This guy needs to get fired. We know this DA needs to go to fucking a home, right? And they got to stop doing this, dude.
I will pass the witness to the defense.
Mr. De Hoyos?
Just a second, Your Honor.
De Hoyos.
Deputy, I couldn't help but notice that through the course of your testimony, you were either looking at something on your computer screen or reading something. Do you have your report in front of you?
I do.
Have you been looking at that and reading through it as you answered the questions from the prosecutor?
Some, yes.
Okay. Your Honor, I'm going to ask that you strike the deputy's testimony. And the reason why is because in accordance with KSA 6419, the prerequisites of knowledge and experience, the witness is required to testify from their recall, from their knowledge, from their remembrance of these issues. And in the event that they are going to testify from some item that has to have a foundation for laid out for. Now, it's true the state can reply or can provide anything to refresh the recollection of a witness. But it is also true that the record has to reflect that that's being done, and this wasn't done in this case. For that reason, because the deputy is admitting that he's reading the report that has not been used to refresh his recollection, and that I don't have in front of me neither, nor did I know he was reading it until I asked him. I don't believe that the witness qualifies under 6419 as provided for in the rules of evidence.
Now, for the record, Deputy, have you been for what purpose have you been using your report today?
To recall the time and the amount that was asked of how much weight was found. Something that I wouldn't know right off the top of my head.
I mean, that would be the reason one would look at a report is to refresh one's memory. But in this particular case, what just happened like less than 20 minutes ago was that you did remember it right off the top of your dome. In fact, in the first line of questioning, this is the only thing that you remembered off the dome.
Is the weight of the methamphetamine that was found?
1.5 ounces or 44 grams.
And then he checks right here
Judge,
to
if I may.
see if he's right.
Go ahead.
Judge, the other problem is that we don't have jurisdiction on the matter, because what he did was he read exactly what the report says about where the stop happened. So we don't have evidence from this witness that this took place in Greenwood County without him violating 6419.
Well, of course, if I find that he has violated the statute and I dismiss without prejudice, we'll just be back here again. Is that your preference, Mr. De Hoyos?
Judge, respectfully, I don't know that that's exactly how the case law interprets it.
And that's not how it would be interpreted, because it doesn't need interpretation. Because if something is presented as hearsay or as a story with no evidence to back it, then you present the evidence to back the story you just said. It's not evidence to back a story anymore, right? It becomes nothing, right? But you know what I'm saying? But if you present it as evidence and then tell your story about it, you know what I mean? You present it as evidence first and then tell your fucking stupid story as a witness, then it's okay, you know what I mean? But you can't present it after you tell the story. You get up on the stand, tell a big fake story, and then present evidence of that story? No. No. And since that's the only thing linking her to this location, then it becomes a matter of jurisdiction, you know what I'm saying? But she doesn't understand this, and I don't think he really wanted to take the whole time to explain that, you know what I mean?
I might review that a little bit closer to see if that's how this would come out, but I do think that we have to do things by the book, and this just hasn't been done this way.
All right, Ms. Gillett, your response to defense counsel's objection that I'm not sure is timely made, but maybe he wouldn't have known to make it more timely. I don't know. Ms. Gillett?
Your Honor, officers can refresh their recollection with their reports. Very specific numbers such as the mile markers, weights, dates. They're allowed to refresh their recollection. It is a report that's already been provided to the defense. They have a copy of that affidavit. It is something that they've had access to from the beginning, when it was sent.
It doesn't matter if he's had access to it. I have access to a pile of poop, you know what I'm saying? Unless I'm sure that you're going to use that pile of poop in our court case, then I'm going to ignore the pile of poop and probably not try to look at it until I need to, or until I'm forced to, until somebody tells me to, you know what I mean? It doesn't matter if you had access to it. The fact is, you presented him as a witness, but then did not say anything about the affidavit that he was going to literally be reading word for word for. That's your mistake. It should be dismissed. Fucking Victory de Hoyos, you know what I'm saying? But of course, Webster is an old bat that doesn't know new tricks.
On August 20th. So I believe that the officer is allowed to refresh their recollection. Often they'll ask if they can look at their reports. I didn't notice that he was referring to his report, but they often do so, and they often have them in front of them when they are testifying. I believe the officer would have an independent recollection of Highway 400 and the area in which this specific stop happened is kind of.
She literally should be disbarred for that right now. She just became a witness and then entered into the testimony the exact location that they're talking about, and she stated it as a fact. Like, she cannot do this.
Smack dab in the middle. It's not close to the edge of the county, because our county starts at.
Now she's testifying as a witness. You know what I mean? This is so bad.
19 on one end of the county and ends at 5152 at the other end of the county. So I think we would know that this is kind of smack dab right in the middle of the county and didn't get near any edge of the county as well. So he would know independently that it was within the borders of Greenwood County. Again, he would be just refreshing his recollection. I'm sure he was looking it over before court, because they often do, to make sure that they're refreshed in what happened in their case.
Right. Well,
dude, she has zero understanding of what jurisdiction is.
the objection is noted. It is an understandable and appropriate objection. However, I'm going, since it wasn't made earlier, again, not that Mr. De Hoya would have known to make such an objection earlier, but I don't find that the testimony as given today prejudices the defendant. And if the case is dismissed at prelim, it can be refiled. So the officer has told us he used his report for a limited purpose to refresh his memory. I'm going to go ahead and overrule and allow Mr. De Hoyos. Thank you.
Thank you, Your Honor. Just a second to go on here.
Okay.
Officer, is there something illegal about having a vehicle registered at a different address than the address on your driver's license?
No, not to my knowledge, but not having your driver's license up to date with your current address is an arrestable offense.
Officer, I'm going to ask that you not answer questions I didn't ask you, including any of that last part of that answer. So to be clear, though, it is not illegal to have a car registered in a different location than your address on the driver's license. Is that right?
Not to my knowledge, no.
Thank you. Officer, you said that upon her getting out of the vehicle, you saw what you call a cut plastic straw. Is that correct?
Correct.
And is that the same thing that's captured in evidence through the photographs of this matter?
Correct.
Okay. Can you describe what the straw looked like?
It's pink, and I would say probably about 2.5 to 3 inches long.
Okay. Now, officer, you acknowledge that at that time you did not have probable cause to do a search of the vehicle. Is that right?
Correct.
Okay. So, officers, I understand that after you ran her license and ran the tag, you had no wants or warrants for her that you were aware of.
Correct.
Okay. So at that time, outside of providing her a ticket for the traffic violations you're reporting, she should have been free to go about her business.
Well, I was still dealing with the matter of seeing a cut plastic straw, which gave me more reasonable suspicion to believe that might have been something in the vehicle, on top of the arrestable offense of not having her address up to date on her driver's license.
When did you make contact with Officer Cordell?
I don't know the specific time.
Okay. How long was it from the beginning of the stop to the time in which Officer Cordell arrived?
I don't know the specific time.
Okay. As I understand it, you testified that the defendant locked her vehicle after getting out of it both times?
Correct.
Okay. And she informed you that she was not going to consent to a search of her vehicle.
Correct. That was after the canine had performed the free air sniff.
Okay. But she nonetheless informed you she did not intend to consent. Is that right?
Correct.
And under the United States Constitution's Fifth Amendment, she doesn't have to assist you. Is that right?
Correct.
Okay. And she never told you that she locked the door, but you said she did not provide a clear answer to questions you resolved about how she was going to get back into her vehicle.
I don't understand what you're asking. I'm sorry.
Well, you had mentioned that she did not provide a clear answer. A clear answer to what?
Where the key was.
Okay. And her right to remain silent, she doesn't have to provide that, does she?
No.
On the document that shows us the, forgive me, the forensic laboratory testing, was the THC that was analyzed show what percent was THC?
I don't know. I don't have the report.
Okay. Are you familiar with the Farm Bill and how much THC must be in a plant before it is unlawful?
No.
Okay. Were you able to conclude beyond, or even with the preponderance of the evidence, that the THC therein collected was above the 0.03 threshold for the difference between THC and hemp?
So I don't know what that threshold is. All I know is I was able to smell the odor of marijuana after I opened the container.
Can you tell me what the difference in smell between marijuana and CBD is?
No. I know what I know to be marijuana is what I smelled.
Okay.
Judge, I'm going to object to this line of questioning further. Deputy Fisher is a deputy. He's not the KBI lab technician. These questions are more appropriate if we were trial setting for a KBI lab technician who does the further testing of
Are you fucking serious? The balls on this bitch, dude. She literally just introduced evidence that was that was fabricated on the scene by the deputy. Yet when he asks about his understanding of that evidence, and then she says, "Oh, he's not a KBI lab technician." But he can test the drugs and tell you that it's methamphetamines without a lab technician, but he can't answer a question about it. This bitch is crazy.
substances.
Your Honor, if I may, I don't have any more questions around this line of questioning. I've asked what I wanted to, and I'm not going to ask anything more about that subject.
Right. Objection sustained, and Ms. Gillett, you can call your next witness if you have any.
Just a couple of rebuttal questions for Deputy Fisher. Deputy, did Sergeant Cordell arrive about the time you were handing the warning ticket to Ms. Stowe?
I don't recall the exact time that he arrived.
Do you remember if it was about concurrent to the timing of the warning being issued?
Objection asked and answered.
Sustained.
And Deputy, did you have to write out a warning for her?
I was writing out one, yes.
And I believe that's all my further limited questions were.
Mr. De Hoya, any limited redirect or recross?
Deputy, you were not obligated to provide her a warning of any kind, were you?
No.
No further questions.
All right, any further witnesses, Ms. Gillette?
Your Honor, the state will call Sergeant Cordell.
All right, thank you. Deputy Fisher, you may come or stay if you wish.
Thank you, Deputy.
Sergeant Cordell, please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you. Please proceed, Ms. Gillette.
Could you please state your name for the record?
Sergeant Mike Cordell.
And how are you employed?
I am a patrol supervisor and canine handler for the Greenwood County Sheriff's Office.
How long have you been employed with the Greenwood County Sheriff's Office?
I've been with the Greenwood County Sheriff's Office since, I believe, November of 2016, and I've been full-time certified law enforcement for just under 22 years.
And were you on duty on August 8th of 2025?
Yes.
Were you asked to go to Deputy Fisher's traffic?
Yes.
And do you recall when you arrived there?
So when I deploy my canine, I initiate a deployment log, which serves as my supplemental report. And the time that was documented on my deployment log was 0119, so 1:19 in the morning, which would have been shortly after my arrival. So it would have been sometime before, but close to that time frame.
And Sergeant, do you have your deployment log in front of you?
I have it. It's not in front of me. It's on my computer, which is closed.
And did you end up deploying K9 Kilo on this vehicle?
I did.
Okay. And are you training currently with a new K9 partner?
Yes, I'm still certified with Kilo as a team, and I have a new canine partner that I'm actually leaving Monday to go to certification with so that Kilo can retire.
And is Kilo retiring because of age?
Yes.
Still nothing wrong with the smell or just age?
No, he still works. He's just he doesn't show the same excitement for it that he used to, and that over time will start to inhibit my ability to read his body language and cues. That's not the case currently, but I can see that that's on the horizon. So before that becomes an issue, we're replacing him with a fresh canine.
Okay. And so you had ran Kilo in this stop. Were you currently certified at the time of the stop?
Yes, my most recent certification was it was a 1-week certification through Kansas Police Dog Association, which occurred in the week overlapping the end of April, beginning of May. I want to say it was April 28th through May 2nd. I may have those dates slightly wrong, but it was a week-long certification training.
And do you keep up on Kilos in between training?
Yes, ma'am.
Do you keep training logs?
Yes, for most of my training. There are times I do a quick training and I fail to log it, but for the most of the trainings, yes, I do.
And so at the time of the stop, did Kilo have an alert to this vehicle?
He showed alert behavior and a final indication at the driver's side front door seam area.
Now, do dogs indicate on an amount of drugs or an odor of drugs?
The dog indicates, alerts to and indicates to the odor of a drug for which he's trained.
What drugs is Kilo trained to recognize?
Marijuana, methamphetamine, heroin, cocaine, and fentanyl.
And when Kilo alerted, were there any other spots on the car that he alerted to?
If I remember correctly, I believe he showed alert behavior at the passenger front door area, but no final indication, and I continued to run him. So he's trained when he is in odor. I can see the change in his behavior when he detects an odor, but his training is to locate the strongest source of the odor. That's where he gets rewarded. So he attempts to locate the strongest source of the odor, and then that's when he gives final indication.
Okay. And it's just the alert that is necessary for probable cause.
Correct.
And Kilo, with his alert, what's his final indication look like?
He sits and stares at the source of the odor.
And did you assist in the search of the vehicle?
I did not. I assisted in gaining entry. I did not assist in the search as far as I can remember off the top of my head.
Okay. And did you also see the cut tutor straw in the door panel?
I did see it after. So Deputy Fisher advised me of it. When I'm responding to a canine call and I discuss with the deputy, they the first thing I ask about is any issues that would be a violation of USV Rodriguez, which is the detention of the vehicle. He advised me of expired insurance, as well as the improper address on the driver's license. And then when I arrived on scene, he advised me of the tutor that he had seen in the driver's side door pocket. I didn't see that tutor until after he had removed it from the vehicle, but he did advise me of it prior to removing it.
And I believe that's all my questions for the sergeant. I will pass him to the defense.
Cross-examination?
All right, let's start from the beginning. So Kilo is retiring, is that right?
Yes. One of the factors too is that he is trained in marijuana. So in addition to his age, and I can see on the horizon that he's ready for retirement. He also is trained in marijuana, which quite frankly, I believe it'll probably be legalized at some point, and I don't want us to be caught in a situation where we have a dog that alerts to a inherently legal substance.
Oh, really? Is that a factor? Then why did you just arrest somebody for having an FDA-approved 100% absolutely legal substance called methamphetamines? There is nothing illegal about methamphetamines. It is prescribed by doctors and made in pharmacies and sold to people, or made in pharmaceutical companies and sold from pharmacies to people. It literally methamphetamine, right? There's no, it's not Adderall, it's not Ritalin, it's actual methamphetamine. You can go buy it, you can get it at Walmart if you have a prescription. So why would that be a factor if it's inherently legal? You fucking
Because then we'll be right back here talking about that. So.
As you see here, and oh, by the way, your doctor will prescribe this to your 6-year-old if your 6-year-old is diagnosed with ADHD. So, yeah, we're giving meth to kids. You know what I'm saying? So I don't know how you can sit there and say what you say there, chief or whatever, deputy, whatever your name is. Here's the chemical breakdown of it, right? And disoxin is the registered name of it, right? The copyrighted, patented, registered name. And I know some of you are probably already Googling what hydrochloride is. It's salt. It's just like the little shell they put on the outside so you can swallow it better. It's literally methamphetamines. And the FDA approves of this 100% right here. FDA approved, baby.
Trained in marijuana, which quite frankly, I believe it'll probably be legalized at some point, and I don't want us to be caught in a situation where we have a dog that alerts to a inherently legal substance, because then we'll be right back here talking about that. So,
So are you telling me that here soon there will be a canine narcotics dog named Kilo available for adoption?
That's hilarious. Yeah, because he said he's gonna replace him, right? So yeah, so you're saying if you're gonna replace him, so you're telling me there's another dog named Kilo that's up for adoption? That's fucking hilarious. Nobody thinks that's funny.
No, not at all. I might have to fight over that one. So he'll stay with me.
Good for you, Sergeant. All right. All right, let's talk about the stop here a little bit. You had mentioned that the dog searches for its strongest point of odor. Is that right?
Yes. So he does what's called bracketing. When he locates an odor, you'll see a sudden head turn where he's sniffing along the vehicle. He finds an odor for which he's trained. He'll kind of snap back to that odor and he'll search that area for that odor. Sometimes he'll move on, looking for the strongest source. Sometimes he'll stay in that area, but his training is to locate the strongest source of the odor. So in training, if let's say we're working lockers and the odor is in the top right locker of a bank of 4 lockers, and he indicates at the bottom locker because the odor is sinking, he won't get rewarded until he finds it in that top locker and hones in on the strongest source of the odor.
Doesn't that mean that you have to take him back to the spot? I mean, to compare which one of those odors was stronger?
No, so he like I was saying, he does what's called bracketing, where he'll kind of sniff around until he finds the strongest source, and then
Chemistry section submission guidelines. Okay. What are these guidelines?
he alerts to that location. So we work on that in training. In the field, I don't know if the odor's stronger on the passenger side or the driver's side. I go off of his alerts because that's an unknown find. But he in training is taught to find the strongest source of the odor.
Now, I want to make sure I understand that Deputy Fisher told you that the driver
Is Jill Gillett a federal prosecutor? Because this says methamphetamine quantization will only be performed on federal cases and federal prosecution and sentencing guidelines, blah, blah, blah. The name and contact information of the federal prosecutor needs to accompany a request for analysis. So seeing as they got the analysis back like she claims, then that means there must have been the name of a prosecutor attached to that, right? Wrong, right? Because she's lying. I rest my case.
Now, I want to make sure I understand that Deputy Fisher told you that the driver's insurance was expired. Is that correct?
At the time of the phone call, when I asked if there were going to be any Rodriguez issues or where we stood on that, he advised me at that time that she had expired insurance.
Okay. That would be in his report then, because that would be indication of something unlawful. Is that right?
I can't speak to what's in his report. I know that I notated it in my supplement as to one of the things I was advised of.
Okay. And if I understand your testimony right, he showed you the tutor that he collected from the vehicle. Is that right?
So I don't recall if he showed it to me prior to collection or if he showed it to me after he collected it, but he did tell me about it prior to searching the vehicle, and then did in fact locate the tutor exactly where he stated it was.
So if he wrote in his report that you provided him with a tutor in the front driver's side door panel, that would be wrong.
You know, I know he told me about it prior to the search. I don't recall assisting in the search. I do recall assisting in entry to the vehicle. I haven't watched the video or really thoroughly read my report.
Bro, it even goes as far as to tell them what their legal authority is, right? It says a search warrant. No, they didn't have that. Consent. No. Abandoned property. No. Exigent circumstances. No. They broke this lady's window and fucking gathered the evidence or whatever and sent it to them for no reason because they didn't even have the authority to do so. But yet they somehow get it back, dude. I don't believe any of the shit that Jill says. I think that document, you can literally download a PDF of that exact layout and then just fill in the information. I don't even think it came from the Kansas Bureau of Investigations.
Because I do recall the important details of the incident. Is it possible I collected it out of the door after he told me about it? Yes, but my recollection at this time is that he collected it. I could be mistaken on that because, like I said, I'm just going off of my recollection on that. I do know that he told me about the existence of that tutor in the driver's side door pocket prior to us making entry to the vehicle. And then I also know that it was located in that spot. I may have collected it. I don't recall collecting it, but I might have. That would be on my video, which I assume has been provided. I haven't reviewed it.
Okay. Just a moment. To be clear, you didn't find scales, multiple baggies, like empty baggies, or thousands of dollars in any location at which you did the search.
I don't recall conducting any portion of the search, but I didn't recover the drugs themselves. Those were recovered by Deputy Fisher. If I recall, there was a large quantity of methamphetamine that was divided into 2 bags. But other than that, no, I don't believe he located any scales or empty bags.
Okay. Judge, that's all the questions I have for the limited purposes of today.
Thank you then. Ms. Gillette, any redirect?
No, Your Honor.
All right. Any evidence for the defense at this hearing?
Not for the limited purposes of today, Your Honor.
No. At this time, I find probable cause exists on count 1, unlawful distribution of the controlled substance methamphetamine/MDMA, or possession with the unlawful intent to distress or to distribute. Count 2, unlawful possession of drug paraphernalia with intent to distribute. Count 3, interference with law enforcement. Count 4, no drug tax stamp. The remaining counts are misdemeanors, so I bind the defendant over on each of those felonies. Missy, when will the arraignment be?
This case goes to Judge Hart and he is available January 22nd at 9 o'clock.
Council available January 22nd, 9 a.m. And Missy, that's via Zoom.
Yes.
And just a second, Judge.
You will.
Hey, Jill, can you confirm this with me? Isn't that when Teresa Whitney Heron has her arraignment as well? Is that in front of Judge Hart too?
It is.
Okay, then yeah, I should be there, Judge. Although, fair warning, we are any of the next, 9 days, I'll become a dad, but we'll see.
Good for you, man. That's badass. I have a nephew, but I have no kids.